Okay, I think we'll go ahead and get started. Hello, everyone, and welcome to our webinar. My name is Jennifer Burnett, and I'm the Director of Fiscal and Economic Development Policy here at the Council of State Governments. This program is part of CSG's E-Academy series, a bi-monthly webinar series designed to provide information and training on the most critical issues facing state leaders, including the latest trends in state policymaking and cutting-edge state solutions. Founded in 1933, the Council of State Governments is the nation's only organization serving all three branches of state government. CSG is a region-based forum that fosters the exchange of insights and ideas to help state officials shape public policy. During today's program, we're going to hear more about the legal landscape of public employee pension reform. But first, a couple of logistics. First off, this webinar is being recorded, so if you miss anything, it will be available soon on our website, csg.org. Also, as I mentioned before, this program will be about public pension reform, and any questions you might have, you can type into the little interface there on the side of your screen. And if it makes sense, the speaker today will answer those questions as he goes along. Otherwise, he will be answering them at the end. It will be about a 1-hour presentation today. So now I'd like to introduce our speaker, Alexander Volokh, who is an adjunct scholar with the Reason Foundation and a professor. He is a professor. He earned his bachelor's degree from UCLA and his JD, as well as his PhD in economics from Harvard. He clerked for Judge Alex Kaczynski of the Ninth Circuit and for Supreme Court Justices Sandra Day O'Connor and Samuel Alito. He now works as a professor at Emory University. And before coming to Emory, he was a visiting associate professor at Georgetown University Law Center and a visiting assistant professor at University of Houston Law Center. So with that, I'll turn it over to Professor Volokh.
Thank you very much. So today I'm going to be talking about various constitutional issues related to public pensions. And the most important constitutional provision related to public pension reform is the contract clause. So I'm going to spend some time first talking about the background of the contract clause and what that's all about. So the contract clause, it's actually a clause in the original Constitution of 1787, and it says no state shall pass any law impairing the obligation of contracts. Now, there's a sense in which this is a little bit unusual because today we understand that the Constitution applies to the federal government, also applies to state and local governments. So the federal government can't violate your First Amendment rights, and neither can the government of New York State or the municipal government of San Francisco or whatever. At the enactment of the Constitution, that was not the case. In the first place, in 1787, there was not yet any Bill of Rights. But then even when the Bill of Rights was adopted in 1791, it was clear that the Bill of Rights only applied against the federal government. It had no applicability to state governments. So, for example, the first sentence of the First Amendment is Congress shall make no law, etc. So Congress couldn't violate your First Amendment rights, but the U.S. Constitution had nothing to say about what states did to you. The states had their own constitutions, and those constitutions had their own free speech protections and other things, but it's not something that the federal Constitution really cared about. So that's the background. That
the broadcast is now starting. All attendees are in listen-only mode.
I'm sorry, I just got a strange announcement. Am I still here? I'm going to talk to those.
You're still on.
Okay.
You're fine.
All right. Anyway, the background rule is that as a general matter, the protections of the U.S. Constitution only applied against the federal government. It wasn't until after the Civil War, with the passage of the 14th Amendment, that many of these rights started to apply against state governments too. So for the first many decades of the Republic, there were virtually no protections that people had in the U.S. Constitution against their state government. So the Contracts Clause is a big exception to that, because what were the founders concerned about? One of their big concerns, something that actually happened quite often during our earlier Constitution, the Articles of Confederation, is you would have a state, let's say, for example, there are farmers in Georgia that have mortgages on their farms which come from bankers in New York. And maybe the economy isn't doing very well, and now the New York bankers want to foreclose on the Georgia farms. What if Georgia passes some kind of foreclosure moratorium, which basically impairs the obligation that the Georgia farmers have to their New York bankers? The founders saw that sort of thing happening under the Articles of Confederation. They were horrified by that, and they thought that was contrary to morality and justice and sound principles of government, and they wanted to make sure that states did not pass such laws impairing the obligation of contracts. So this is one of the very few prohibitions against states. For example, states also can't coin money, they can't grant titles of nobility, and so on. But the obligation of contracts, that is the major prohibition on states there. And for maybe the first 100 years, the Contracts Clause was the most litigated provision in the whole U.S. Constitution, and routinely the Supreme Court would strike down state laws that weaken contracts, for example, that favored debtors over creditors and things like that. Now, during the Great Depression, a lot of portions of the Constitution got, you might say, watered down. That happened with the Contracts Clause too. In all fairness, toward the end of the 19th century, the Contracts Clause was already getting somewhat watered down, and the Supreme Court was finding more and more cases where if a state altered the rules around contracts, that was still going to be okay. But in the 1930s, there was a case called Blaisdell, where the state of Minnesota, during the Great Depression, had enacted exactly what I just described in my hypothetical. It had enacted a foreclosure moratorium. And it would seem that would be one of the clearest examples of a state impairing the obligation of contracts, and yet the Supreme Court upheld that, saying that it was essentially justified by the economic emergency. So at that point, a lot of people thought the Contract Clause was dead. But in the 1970s, there was a case, U.S. Trust Company, and there the Supreme Court said, no, we still have a contract clause. It's not actually dead. It still does have some bite, and it applies especially when the state wants to impair the obligation of its own contracts. There's a foreclosure moratorium. The state is not a party to those contracts. It's a property owner versus a banker. But on the other hand, U.S. Trust Company of New York versus New Jersey, that was a case related to the New York Port Authority, which is co-owned by New York and New Jersey, and the Port Authority had issued bonds, and bondholders now bought the bonds, but the states had made a contractual commitment to these bondholders that we're only going to use the revenues of the project for a narrow set of circumstances, and the result is there's therefore going to be more revenues available to pay you, the bondholders. So the bondholders had bought the bonds under that assumption. And now a decade later, the states decide, oh, we have these revenues. We would really like to spend those revenues on other things. And so what they did is they reneged on their original commitment, even as to bonds that had already been issued. And the Supreme Court said that was no good. That was the states of New York and New Jersey that were trying to renege on their own contractual commitments, and that impairs the obligation of contracts, and we should take a strict view of that, because when the state is a party to the contract, then it has more of a self-interest in reneging on the contract, because when you renege on a contract, it's true people might be less likely to want to deal with you in the future, but at least you get a benefit right now, which is that you don't have to honor your contractual commitment. So the Supreme Court said that the contract clause still exists and we're still going to enforce it. Later cases developed a three-part test. First, the court is going to ask, has there been a substantial impairment of a contractual relationship? So if the impairment's not substantial, we don't really care very much, but if it has been substantial, then we go on to the next step. And we say, well, does the state have a significant and legitimate public purpose? So that's going to be the first step for the state to make an excuse for impairing contracts. And even if the state does have a significant and legitimate public purpose, the impairment has to be reasonable and appropriate. So if the state can establish those two things, then it can justify a substantial impairment of a contractual relationship. But you can always defeat the state by showing either that the state does not have a significant and legitimate purpose, or that even if it does, that the impairment is not reasonable and appropriate. The impairment is too large or something like that. So that basically is the background of the contract clause, and this is a clause that's used most often in litigation over public employee pensions. Can I have the next slide, please? So initially, we have to ask ourselves, why would the contracts clause apply at all? Normally, when you have an employment contract, now, if the employer and the employee sign a contract, then that's great. That's clearly a contract, and then the contract will say various rights and responsibilities. The difference is that pensions, the precise rules of how pensions are calculated and what kind of pension are you entitled to, usually there's not a written contract that establishes that. Rather, you go to work for the government, and the legislature passes statutes saying, here are the pension rules that are going to apply. So, for example, the rule might be your pension is going to be based on your ending salary, and for every year that you work, you get 2% of your ending salary as your pension. So if you worked for 40 years, for example, you get 40 times 2%, so you get 80% of your ending salary. So that's an example of a pension rule where the ending salary is the base amount that everything is calculated off of, and 40 is the number of years of service, and 2% is the so-called multiplier. And that's an example of a simple rule. And the rule might also include that there are cost of living adjustments. It might say here are the employee contributions, here are the employer contributions, and it might have a lot of things like that. So all of those rules would not be written in the contract generally. Rather, the legislature would pass a statute, and so then all those rules would be in the statute book. So the first hurdle you have to clear is, in what sense is this a contract, such that the contracts clause would apply? And usually, usually a court does not read a statute as creating a contractual obligation, because it says, the court says to itself, legislatures are, their main job is regulating society. Their main job is not making contracts. And if you, every time you interpret a statute as a contract, you limit the flexibility of future legislators. So basically, you're allowing legislators to bind future legislators. And, you know, maybe they can do that, but you don't want to presume that very easily. So as an example, if they say, we're going to give a tax break to X industry, and then relying on that, lots of people go into that industry expecting the tax break, but now 10 years later, the legislature decides to abolish the tax break. You can't make an argument that, oh, that was a contractual commitment to us. We're entitled to the continuation of that tax break forever because, look, we relied on it. No, courts are going to say that the tax break was just a matter of policy. And the policy that one legislature makes, another legislature can unmake. And so, yes, you may have entered that industry on that assumption that there was going to be a tax break, but you did that at your own risk. And so if that tax break goes away, that's something that legislatures are entitled to do. So the presumption is you're going to read statutes as not creating contracts. And for a long time, pensions were considered exactly the same, that it was a gratuity that the government was granting you. And the gratuity that they granted, they could also take away, so that the legislature could abolish a public employee pension whenever it wanted to. Now, ultimately, this is a matter of federal law. So the federal government is, or rather, the federal courts are going to look at the statute and determine whether it creates a contract or not. Certainly, if the statute says the words contract in it and is phrased in a way that is very contractual, the courts are likely to find that there is a contract, and otherwise they might be likely to find that there's not. But usually, courts are going to look to how state law defines the statute. So as an example, there are these two very nice cases that happened one after the other in 1937 and 1938, and they show how the U.S. Supreme Court came to opposite conclusions regarding whether a particular statute created a contract. So in Dodge v. the Board of Education of Chicago, the legislature had fiddled with various public employee pensions. They had done so retroactively, so they changed the pensions even of current employees. And those current employees sued, and the U.S. Supreme Court said, well, no, actually, these pensions are gratuities, and the legislature can abolish them if they wanted to. But they didn't just say that. They actually looked at Illinois law, and it turns out that under Illinois law, that is how pensions were treated. And so they said, well, since Illinois law treats pension statutes in that way, it makes sense that when a particular pension statute is enacted, the legislature is presuming that they are only creating a gratuity, which they then can abolish. On the other hand, in Indiana, there was an Indiana public school teacher, and she was subject to the Indiana teacher tenure law. And eventually, Indiana repealed the teacher tenure law even as to current teachers, so even as to her, Mrs. Anderson. So Anderson sues, and the U.S. Supreme Court says that, no, actually, that tenure law is contractual. And they looked at previous Indiana cases, and they looked at the way that the Indiana teacher tenure law was phrased, and they said, well, Indiana law has always been treating that law as contractual. And so now, when the current legislature repealed it, they were abrogating a contractual obligation that already existed, and so that was unconstitutional. So usually courts are going to look to state law to find out whether a particular statute creates a contract. Can I have the next slide, please? So today, most states have gone away from the gratuity theory. And now they say that a pension is really just deferred compensation. And so it's just as contractual as a salary. And this makes a lot of sense because you should just imagine a very simple case. Forget about pensions. Let's suppose that we pass a statute saying that a public employee gets a salary of $100,000 payable at the end of the year on December 31st. And so you start work on January 1st, and you're working, and you're expecting that you're going to get the $100,000, which is in the statute, and you're working, and then on December 30th, the legislature repeals the statute. Now that seems like that shouldn't be done, and that seems like clearly a case where the state is trying to get out of a contractual obligation, because you have done work, and so you have, it does seem like you're entitled to that $100,000 because you went to work in reliance on the existence of that statute. And it would be unjust for the government to try and get out of that by just repealing the statute on the last day before your payday. So in other words, the existence of the statute is one of the background conditions of the deal. So when you made the deal to go work for the government, even though they didn't spell out all of the rights, it was clear that you were entitled to some kind of salary, and it was clear that that salary was the one that was referred to in the statute. So all of those circumstances together combine to make us think that that kind of salary statute really does create a contract, even if it doesn't say so explicitly. But that's the sort of statute that's reasonable to think of as a contract. But if that's the case, then if you think of a pension as being just a portion of compensation like any other portion, so I can bargain to have money, I can bargain to have a corner office, I can bargain to have a really nice parking space, and I can bargain to have some of my salary being held and given to me when I turn 65. So a pension is just as much compensation as a salary, and so most states, I think, have made the right decision in concluding that a pension statute basically creates a contract. Now, that has not been the case everywhere. There are some places that still have the gratuity approach. So I've seen a case in Arkansas, and they said that at least for pensions that have no employee contribution component, that is still considered a gratuity. That doesn't seem right to me, but that's how some places do it. There are states that consider that the public pension is not a contractual right, but rather a property right or a property interest. And there are 3 separate property approaches. They're actually easy to confuse with one another. And a lot of state courts are not really very careful about how they use terms. So sometimes the opinions have a sloppy feel to them. So the weakest type of protection would be to say that it's a property interest that can't be eliminated without due process of law. That's in the Fifth Amendment, and also in the 14th Amendment, there is the due process clause, which says that no one should be deprived of life, liberty, or property without due process of law. So that's where that comes from. The thing is that that's a very weak test because it accepts that you could be deprived of property if there is due process of law. And what does that due process consist of? If you're talking about a statute passed by the legislature, the courts have held that the legislative process itself is due process. So if the state legislature passes the law using the normal legislative methods, like, for example, at the federal level, the House approves, the Senate approves, the President signs, the standard way that a bill becomes a law, that actually is due process of law. And there's only a very minimal restriction, which is that the law can't be totally arbitrary. But as long as a court can think up any rational basis for the law, then they would uphold it. And a rational basis is something very minimal. So like the state might say, well, we had a fiscal crisis and we needed to save money, and this was a way of saving money. So the property interest / due process approach is very weak, and I've seen that being used in some cases from Maine and Connecticut. And there are other places too. Now, some states that say that it's a property right, they mean property right in a more basic sense. There's the sort of property that you have in your home. So if the government wants to take your home from you, there's the takings clause, which requires that they pay just compensation. So if you eliminate my pension or just reduce my pension, then you have to pay me the difference. So I mean, if that's the rule, then it's not worthwhile reducing your pension if you just have to pay the difference. So the takings clause approach, that might be just as strong as the contractual approach. And I've seen that taken in a case from New Mexico. Now, there's the takings clause, the strong version of the takings clause for when your home is built, for when your home is taken. But there's also a weak version of the takings clause. Let's suppose if the government they don't take your home, but they regulate your home to such an extent that its value falls to zero or to something close to zero. So for example, what if you had a beachfront home and the government adopted various beach protection ordinances that prevented you from developing your property? The Constitution does provide some protection to the homeowner in those cases, but a sort of weak protection, and that's called regulatory takings doctrine. I know I've said that Maine and Connecticut use the property interest approach, but I've seen some other cases, some federal cases, where the federal court was interpreting Maine and Connecticut law, and they cite the regulatory takings doctrine. So it's possible that both approaches are true to a certain extent in those states. So those are the three property approaches. The property interest approach is very weak. The regulatory takings approach is sort of weak, but the property rights / takings clause approach is actually very strong. And then finally, the other approach, which is taken in Minnesota, is it's kind of like a contractual approach, but in a modified sense. It's called a promissory estoppel or reliance. So in other words, they protect your pension if you reasonably relied on it. So if you have a pension and the government takes it away, but you haven't relied on that pension, then that's okay. But if you have relied on the pension, then the court might give you some relief. That is an approach which has been accepted in very few places, maybe only Minnesota. One of the weaknesses of the approach is that it seems to give you different protection depending on whether you relied, and so that means that the extent to which your pension is protected, it might be different for every individual. Not only that, but the person who was really frugal or really paranoid about whether the pension was going to be there, and so they didn't touch their pension, they might find that they have no protection because they didn't rely. And on the other hand, the person who borrows against the possibility of a future pension and spends all his money and builds a home or something, that person might be thought to be more profligate, and but because that person relied, they might have better protection. So that's a very minority approach. In most states, it's the straight-up contractual approach that says that a public employee pension is a statute that creates a contract because it's reasonable to think that that's part of the deal that you accept when you go to work. I should mention also, I had said that state courts are often fairly sloppy about their use of terms. Sometimes one of their sloppinesses is they sometimes throw the word vested around to say that, well, your pension is not protected because it hasn't yet vested, or your pension is protected because it has vested already. All I'm going to mention here is there are a lot of technical issues there, but the only important thing is that if you read a case and you see the word vested, you should know that that often means really different things wherever you see it, and there's really no consistency in how courts use the word vested. So that's just a sign that courts are often sloppy with this area of the law. Can I have the next slide, please? So now the question is, so suppose you're in a place where it's clear that a pension creates a contract, but still the question is, what is in the contract? And this is an area where, again, different states will differ on, it's just a matter of state contract law, what exactly is protected by the contract. So as an example, let's suppose that I go to work for the government and there's a statute that says your pension is going to be based on your final salary, and the multiplier is 2%. So if I work for 10 years, that entitles me to 20% of my ending salary. Okay, that's clear enough. Now, what if the legislature 10 years in changes the rules and says, no, actually now the multiplier is going to be 1%? You could imagine two different approaches. One approach could say that you were working for 10 years under the one set of rules, and you accumulated the right to a pension that's equal to 20% based on those 10 first years of service. But now that the legislature has changed the rules, now you're going to be accruing under a different set of rules, and those are the rules that apply. It's as though they fired you and then rehired you as a new person. So the amount that you accrued for your first 10 years is absolutely protected. That can't be reduced. But the amount that you're earning going forward, that's also protected, but you're not entitled to having that 2% remain at 2%. So a lot of states do take that approach. For example, Maryland is one such state, and it says that pensions are accrued in a prorated way. Future pension benefits vest as they are proratedly earned is the way that a court has put it. Now, we could also imagine a much stricter version of what the contract protects. So imagine I could make this claim. When I started work, I was entitled to a pension that was based on my ending salary, and the multiplier was 2%, and so on. And so on day one, I had the right to exactly those rules that were in effect. So I am entitled to a 2% rate forever, basically, for the whole time that I'm on the job. And let's suppose that also the rules say that I get a 3% cost of living adjustment every year. Now, I'm entitled to that 3% cost of living adjustment every year. So 10 years in, the government is not allowed to reduce the 2% to 1%, even if they do it purely prospectively. As long as I stay in that job, I am entitled to all the same rules that existed on day one when I started the job. Now, of course, the state can still make the rules more generous to me. So they could increase the 3% cost of living adjustment to 4%. They could increase the 2% multiplier to 3%. That's beneficial to me. Once they do that, I then acquire a right to those more generous rules. But what they can't do is make those rules less generous to me. So that's a much stronger view that says that you're entitled not only to the amount of money that you accrue, which is equal to 0 when you start, but increases as you work. This stricter view would say that you are entitled to all of the rules that are in effect, all of the pension calculation rules that are in effect on day one. That rule is called the California rule because that's the law in California, and a number of other states. Arizona has something similar. Illinois has something similar. So there are about a dozen states, but many major states with a lot of the U.S. population in them, and they abide by the California rule. So the California rule, on the one hand, is more generous to the existing public employees. On the other hand, it makes pensions very inflexible because if there is a fiscal crisis, then the state government is very limited in its ability to use pension reform to alleviate that crisis. The interesting thing is that pensions are protected in a way that no other aspect of the job is protected. So like under the contracts clause, let's suppose that you were hired to a job that had really cushy working conditions, and then 10 years in, they made those working conditions miserable. And you sued saying, no, I had a contractual right to all the working conditions that existed on day one. You would clearly lose because there is no protection for working conditions. What if you said, when I was hired, there was a civil service system, and so I was guaranteed that I would have a job basically forever unless I did something awful. And maybe 10 years in, let's suppose the state abolishes its civil service system, which it's allowed to do. And what if you claim that, no, that violates the contracts clause because when I was hired, I was entitled to civil service protection? Again, you would clearly lose because there is no protection for your job tenure. What if you were hired and the salary was $100,000 a year, and then 10 years in, the legislature reduces the salary to $50,000? Again, that's not something that's protected by the contracts clause. But what if you were hired when there was a 3% cost of living adjustment, and 10 years in, the legislature makes it a 2% cost of living adjustment? That is unconstitutional under the contracts clause if you're in a state that follows the California rule. So that seems implausible to me. Why should we consider that the contract that you got on day one included all of the rules of pension calculation, but did not include anything else. It did not include your salary, your working conditions, your job tenure, or even the continued existence of the job itself. But in any event, that's what the California rule does. So there are some states that adopt the very flexible rule where changes are always okay as long as they are purely prospective. So I gave Maryland as an example of that. And there are other states, with California being the prime example, which take the very restrictive rule, which is that when you are hired, you become entitled to all of the rules of pension calculation. Can I have the next slide, please? So, okay, that is the federal contract clause. Now, every state has its own constitution, and it's very common in states, maybe every state has this. States have their own contracts clauses in their own state constitutions. Those contracts clauses can always be more generous than what the federal constitution requires. So generally when you're in a state, you need to know what is the federal contracts clause jurisprudence, but you also need to know whether your state provides any extra protection there. But I've already mentioned a crucial way where even under the federal contract clause, what a state does is going to be very important, because just as a matter of state contract law, the way the state characterizes the pension statute, whether they characterize it as a contract or a property right or a gratuity, that's going to be really important even just for the federal contracts clause. So the federal contracts clause really does look to what the state does as a matter of its own law. But in addition, the state contracts clause might also provide some extra protections. And often they don't really, because state contracts clauses often just mimic the federal contracts clause, and they might have exactly the same wording. And like I had mentioned before, state Supreme Courts are often fairly sloppy when they decide these cases. And I've read a lot of California cases, and some of the foundational California cases about the California rule, they don't bother to say whether they're relying on the state or the federal constitution. Sometimes they cite state cases, sometimes they cite federal cases, sometimes they don't even mention the Constitution at all, they just say what the result is. So just because a state has a contracts clause does not necessarily mean that it gives you any extra protection that the federal contracts clause doesn't already give you. Now, in addition, there are some states that have additional clauses in their constitutions that specifically relate to pensions. So they might have a general contracts clause saying contracts shouldn't be impaired, but in addition they might have a pension clause that say pensions shouldn't be impaired, or that say a pension is a contractual right which shouldn't be impaired, or something like that. So there are some states, so California does not have a special pension clause, but Michigan does, Illinois does, Arizona does. So when you have these pension clauses, there's a question, does the pension clause give you any extra protection that you don't already get from your contract clause? So let's take Michigan as an example. When Detroit declared bankruptcy, the case came before a federal bankruptcy judge, and the bankruptcy judge had to determine what did the state pension clause provide. And he said, the state pension clause does not give you anything that you didn't already get from the contracts clause. The only purpose of the state pension clause is to clarify that a pension is a contract, and at that point it just folds in all of the regular contract protection. On the other hand, I've seen cases in, for example, Arizona, Illinois, which take the opposite view, and they say, well, why would we even have a pension clause? It must be because pensions are even more protected, generally speaking, a state might be able to abridge the obligation of a contract as long as it complies with that three-part test that we saw, that I pointed out early in this presentation. Is there a substantial impairment? Is there a legitimate government purpose? Is it a reasonable impairment? And so on. So that might be the rule for states that want to abridge contracts generally, but that if they want to abridge public employee contracts, that is a much stricter rule, and it's going to be much more complicated for them to do that. So that's one thing that you should know about your own state. Does your state have a contract clause in its constitution? And is it basically the same as the federal contract clause? But you should also know, does my state have a special pension clause, and has that been interpreted as going beyond the general contracts clause, or has it just been interpreted to mimic the contracts clause? Just because you have a lot of extra clauses do not mean that you have more protection. So for example, the way Arizona treats its pensions under its pension clause is about as strong as California would treat its pensions under the regular contracts clause. So even though California has no pension clause, it ends up being as strict as the state of Arizona, which does have a pension clause. Or in the same way, even though Michigan does have a special pension clause, but that clause has been interpreted to give no extra protection, relative to states that lack a pension clause entirely. So you should know whether these clauses exist, but it's also important to see how judges have interpreted them and whether they actually give more protection or not. Could I have the next slide, please? So bottom line is, as I've said, you need to understand how your state treats pensions, and you need to understand these aspects of your state con law, whether there's a contracts clause, whether there's a pension clause, how they interact. There are a number of issues which I haven't gotten into, but they're also very interesting, and they merit presentations of their own. One of the issues is bankruptcy. The bankruptcy process, whenever an individual declares bankruptcy or when a corporation declares bankruptcy, the essence of bankruptcy is impairing contracts. So if you go through bankruptcy and at the end of bankruptcy, you pay back however much of your debts you can afford, and the rest of your debts are canceled. So they're just discharged. And what is that but an impairment of contract? So how is that constitutional? The reason it's constitutional is because, go back to the beginning of the presentation where I had said that the contracts clause applies against states and is one of the few provisions that applies against states. Well, the contracts clause does not apply at all against the federal government. So states cannot impair contracts, but the federal government can impair contracts. And not only that, but Congress is given the specific power in the Constitution to pass a uniform bankruptcy law. So we have a bankruptcy code, a federal bankruptcy code. And so as long as you're in federal bankruptcy, it's okay for the federal bankruptcy court to discharge your contract. So what that means is that ultimately, if the fiscal crisis gets too severe, what can you do about it? If you are a municipality, and if your state, your state might allow municipalities to declare bankruptcy. If they don't allow municipalities to declare bankruptcy, then you can't do this. But if your state does allow municipalities to declare bankruptcy, that's a kind of nuclear option, which might be, well, at least it's on the table as one of the potential ways to deal with a fiscal crisis, is that one can go in and get some debts discharged. And so various municipalities have declared bankruptcy, and some of them have emerged from bankruptcy not touching public employee pensions at all, and others have emerged from bankruptcy with very, very deep cuts to public employee pensions. But that itself is its own very broad and fascinating topic, which I'm otherwise not going to get into. In any event, that's all I have to say about that, and I'm glad to take any questions that you may have.
Okay, thank you. It sounds like a couple of people had some audio problems at the very beginning, maybe the first minute or two of the webinar today. So just to reiterate, this was recorded and will be available on our website. So if you didn't quite catch a minute or two, you can check our website in the next week and it'll be up there. And so hopefully that audio will be on there. In addition, if anybody has any questions, we have a little question box here on the side. Just type that in and we will ask Professor Bullock here if he can answer us. In the meantime, I thought I'd ask him if somebody wanted to go find out more information about their own state and whether or not some of these laws apply, where should they go to find that out?
That's a very good question. I am in a little bit of a privileged position because being a law professor, I have access to all of these legal databases and I know how to do research in them. So I would just look up the court decisions talking about the contract clause, pension clause, or containing the words impairment of contracts. Now I realize that might not be available to everybody who is not a lawyer and is not skilled at navigating those databases. So the first thing that I would do probably is now it could be that some organizations within your state have already put together some kind of white papers along those lines. Some of them might be public employee unions or maybe your state government or various think tanks. As an example, one of my papers on the California rule called Overprotecting Public Employee Pensions has been printed by the Reason Foundation, and you can just go onto reason.org and search for my name, and you will find various blog posts of mine, and in addition, a policy guide about these issues. Now, it's not going to help you about your specific state, but you may have some state-level think tanks, or like I said, your state government or public employee union or something that might have put out some white papers. Otherwise, I would Google the name of your state and contract clause or something like that, and maybe you might get something that way.
Okay. Is there anything else that sort of final thoughts here that you would like to offer the audience?
Well, you know, really there are a couple of broad points that I want to make. The first point, which I've already made, but I will sort of reiterate this, is it's one thing to say whether pensions create a contract, and it's another thing to say what is in that contract. So I think some people resist the idea that pensions are a contract because they're afraid that, oh, if I say pensions are a contract, maybe I'm committing myself to too much. And I think the answer is no, not at all. You can say that pensions are contracts, but then still say the contract does not protect as much as the broadest theory might say. I think the most reasonable approach is to say that the pension statute is contractual, but the only thing that's protected is the amount of money that you have already earned based on your service so far. And so that starts out as 0 and then becomes higher and higher. And under that approach, as long as the state alters the pension rules purely prospectively, then that's okay. So for example, a state can always alter employee contributions, and by its nature, that is always purely prospective, and so my preferred approach would not limit that at all. Now, if a state wants to change cost of living adjustments, then it's okay to do that prospectively as long as however much you have already accumulated is put in some kind of law. Accumulating in the future is going to be done by the later rules. So I think that one can accept that the pension statutes create a contract, but then the important question is still going to be, what does that contract protect, and does it protect the most protective possible theory, or does it protect a kind of prorated theory like the one that I prefer? And I think it's important to understand what a state is getting into by adopting a California rule. Like I'd said, if you adopt a California rule, that makes the state really inflexible in how it responds to a fiscal crisis. And so it might need to, instead of being able to respond to a fiscal crisis by cutting pensions prospectively, it might have to make cuts to other things. It might have to make more cuts to government services. It might have to make cuts to public employment generally, maybe firing some people. So this adopting the California rule just takes one of the levers off the table, which might be useful to a state in solving its fiscal problems.
We did have a couple questions come in since I asked you to give final thoughts, of course. Somebody asked, is there a way for states to go apply for bankruptcy, file for bankruptcy?
Yeah, there is currently no state bankruptcy process. So because the bankruptcy is a federal process, and so you can only declare bankruptcy to the extent that the bankruptcy code says that you can. And then there are various chapters of the bankruptcy code, Chapter 7, Chapter 11, Chapter 13, and so on. Chapter 9 is the chapter that relates to municipal bankruptcy. So now, it's one thing to say states can't declare bankruptcy. That doesn't mean states can't be insolvent, and governments get insolvent all the time. That's what, just look at Argentina or Greece. So governments can default. So really what a state does is, if it has a fiscal crisis, one thing that it can do is default on its debts. And it can use the threat of default to negotiate better terms with its creditors, or negotiate bailouts, or something like that. But the problem is that if you don't pay the debts still stay around. So you can't repudiate those debts, because that would violate the contracts clause. So the state is still going to be stuck with those debts. So ultimately, the brunt of the burden, who's going to bear that? It's going to be the taxpayers, who are going to be taxed more, and the users of the government services that are cut. And there might be some creditors who are less protected. It might be bondholders, for example. So there are some commentators who have proposed, because of this, that Congress ought to enact a new chapter of the Bankruptcy Code for state bankruptcy. But at this point, it's all highly hypothetical. And you'd have to write it very carefully to avoid that chapter of the Bankruptcy Code from being unconstitutional. So it's a hypothetical thing that is on some people's radar, but it doesn't seem like it's going to get enacted anytime soon. So at this point, even though there is the concept of insolvency and there is the possibility of defaults, but there is no process for actual state bankruptcy.
I have one more question. If a defined benefit pension is a contract or a property right, then in order to convert to a defined contribution system, a state would have to pay today's present value. For example, what would an annuity cost today to provide the benefit?
Okay, I wasn't clear what part of that was a question.
Yeah, I think they're asking in today's terms, what would it cost today to provide a similar benefit to some of the systems that we've had in the past?
Yeah, well, I think that one thing that I think a state could do is they could pass a statute saying, we are going to abolish all of our defined benefit plans, and we're going to convert them all into defined contribution plans. And as long as the value of those defined contribution plans is roughly the same as the value of the defined benefit plans, then I think that would be able to pass in court, and the state could say, no, this is not a substantial impairment of the contract because the value is basically the same. So that's always a possibility. One thing that states do sometimes, which I've seen, is give employees an option that those who want to can switch to a defined contribution plan. And so the thing about defined contribution plans is with defined benefit plans, the government is committing itself to paying a certain amount, and that's where bad financial planning comes into the picture, because if you haven't put enough money aside, then you might find you don't have enough money to pay. So you have all of these non-fully funded pensions, and so pension underfunding is a serious problem for defined benefit plans. Defined contribution plans like 401ks or 403bs for nonprofits and similar products, they don't have these underfunding problems because you put in however much you put in, and they earn whatever they earn. And so, so a lot of these issues are much less concerning when you've got defined contribution plans. And so I think that if you forced employees into defined contribution plans that were worth a lot less, then they would probably challenge that under the contracts clause, and maybe they would win. But if you made sure that the defined contribution plan was generous enough, then that may allow you to that may allow the government to defeat a contracts clause challenge.
And we have a question, and you mentioned the Reason Foundation. Can you name a few other leading think tanks that write on both public and private pension policy?
That is a good question. You know, I haven't been. I mentioned the work of the Reason Foundation because I'm myself affiliated with Reason. I don't actually follow what the other think tanks are doing, so I don't actually know where else I could send you to for that. You know, generally, if I wanted to find that out, I would probably just Google and find out what think tanks were writing about it.
And I can give you a couple of resources, and it depends. There's a number of resources from the National Conference of State Legislators have some information on their website about pensions. The National Association of State Retirement Administrators has some information, and those aren't necessarily think tanks, but they have a lot of information about their policies and some data and research on a state-by-state basis. The International City County Managers Association also has some information on their website as well.
And also, my white paper that was published by the Reason Foundation was also published by the Federalist Society.
Okay, there you go. Okay, I think that's about all the time that we have. So thank you so much, Professor, for sticking with us for this hour. And if anybody has any questions, you can direct them to csg.org. As I mentioned earlier, we did record this presentation, and it will be made available along with the slides on our website, csg.org, within the next week or so. If you miss anything, feel free to go check it out there. I would like to also say we will be hosting a 2-day intensive policy academy on public pensions and retirement security in October. And if you're interested in joining us for that, or if you'd like some more information, go to csg.org and under events, look for the Policy Academy banner and look for the Public Pensions Policy Academy announcement on there. So that'll do it for today. On behalf of CSG, thank you again, Professor, for joining us, and I hope everyone has a pleasant afternoon.